And I will now recognize the Attorney General.
Thank you very much, Mr. Deputy Speaker. When I opened with the pilot of this bill, I acknowledged the fact that I was standing in for the Minister of Works and Transport, and I emphasize that for the reason that, meaning no disrespect to my colleagues on the other side, questions have been put to me to answer of an operational nature. Regrettably, my remit as Attorney General is not to advise on operational matters. Those questions can be properly addressed to the Minister of Works and Transport in due course and in the proper context. I will seek to address just a couple points that have been made by the other side. First of all, the point has been made that, and I regret that it has been made in the pejorative language that has been used, terms such as favoritism, nepotism, and complacency. The point has been made that this government, of which I am part and proudly so, is seeking to move this amendment for reasons that are palpably beneath the dignity of any member of this House. And that fact is demonstrated by the fact that on both sides, we have stood today and saluted the competence of the board which has served this country as the board of the Civil Aviation Authority, and to suggest that the amendment which is being moved to provide for some sinister motive on the part of the government to keep one or other member of that faithful, competent, and exemplary board in office is to disrespect the service that they have given. Other members on the government side, and most notably the last speaker, who comes with a competence that is exceptional in his area of expertise, the member for Point Fortin, have brought testimony to the language of the legislation that speaks to safety and risk avoidance. That is the language of the Act whose schedule we are seeking to amend. And we are seeking to amend the schedule to delete the limitation on the term of office of the members of the board in order to ensure continuity, competence, expertise, and specialized expertise at that. And I emphasize that. I will not repeat what I have already said. That is the intent behind this amendment. Safety. The other point that has been made, which I wish to rebut, is in the language of the member for Oropouche East, who spoke of a concept which he misapplied, the concept of regulatory capture. The fact is that there is ample legislative precedent for a board's term of office being renewed and extended. And there is nothing pejorative or sinister in the nature of regulatory capture about that. We can look at the Occupational Safety and Health Act, Chapter 88, Number 8, Section 3 of that act, speaking to tenure of office, appoints a board for that authority of 3 years, but outgoing members are eligible for reappointment. We can speak to the Regional Health Authorities Act, Chapter 2905, Tenure of Office, Section 2, Subsection 1. The period of term in the first instance is not exceeding 5 years, as the President may specify at the time of appointment, and those members are eligible for reappointment. We can speak to the Securities Act, Chapter 83, Number 2, Section 12.1. A commissioner other than a temporary commissioner shall hold office for a period not exceeding 3 years and shall be eligible for reappointment. We can speak to the Trinidad and Tobago Electricity Commission Act, Chapter 54, Number 70, Section 4, Subsection 3. A member of the Commission shall, subject to Subsection 4 and the revocation of his appointment, hold office for such period not exceeding 5 years as the President may direct, but a member is eligible for reappointment. We can speak to the Environmental Management Act, Chapter 3505, Section 82.4, a term of not less than 3 years and shall be eligible for reappointment. We can speak to the Town and Country Planning Act, Chapter 3501, Section 3. A member of the panel shall, subject to the provisions of this schedule, hold office for a period not exceeding 2 years, but such member shall be eligible for reappointment. We can speak to the Port Authority Act, Chapter 51, Number 1, Section 3, Subsection 4. The appointment to the office of the Commissioner shall, subject to subsection 6 and 7, be for such period not less than 2 nor more than 5 years, as the President shall specify at the time of the appointment, but any commissioner shall be eligible for reappointment. So our legislative precedents in this republic provide for reappointment of members of the board, and it is no more nor less than that we seek today to do, to ask this House to amend the schedule, Section 2, Subsection 2, to remove the limitation on the term of the board to allow members of that board, one or more of them, according to their expertise and their specialized experience and competence, to provide for the safe air traffic over the skies of this country, to provide for the safety by giving to the government, the President of the Republic, the opportunity to choose from among those serving members with their specialized experience to be reappointed. So there is nothing sinister about that. And therefore, Mr. Deputy Speaker, I've started with brevity. I shall end with brevity. I ask that the amendment be moved, be passed, and Mr. Speaker, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Civil Aviation Act, Chapter 4903, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. Deputy Speaker, in accordance with Standing Order 68.1, I beg to move that the Civil Aviation Amendment Bill 2022 be committed to the Committee of the Whole to be considered clause by clause.
Title: An Act to Amend the Civil Aviation Act, Chapter 40.